Hi everybody, my name is Hayley Mansfield and I'm the Executive Officer of Arc Justice. What a brilliant turnout. Thank you so much for coming along. It's really an honour to be emceeing this event tonight. The issues that will be discussed are ones that personally I feel very passionate about, but also as a leader of a social justice organisation very close to our values and the work that we do every day. Also, I've grown up in Bendigo, so looking out here and seeing such a fantastic response is brilliant. So I'd like to acknowledge that tonight we are meeting on Dja Dja Wurrung country, and I'd like to pay my respects to elders past, present and future. I'd also like to acknowledge that the Dja Dja Wurrung have held sovereignty of this land and possessed it under their own laws for many thousands of years. This is a sovereignty that has never been ceded or extinguished, and the connection of the local Aboriginal people here to land and customs remains very strong. While I think it's always important to acknowledge sovereignty and also dispossession, I think that it's particularly important tonight given the topic that we're going to be discussing. So many First Nations leaders have done so much to advance human rights and speak truth to power. However, human rights protections in this country have disproportionately failed them. I'm sure this is a topic that will be touched on tonight, and I guess as I'm emceeing I might have a little bit of control over that as well. So a little bit about talking justice. Quality public discussion and engagement around justice issues is critical. Our understanding of what is meant by justice has very real and immediate impacts on our lives and on the health of our community. For that reason, in 2014, the Loddon Campaspe Community Legal Centre, which is a program of Arc Justice, commenced the Talking Justice series. And we're really excited this year to have started delivering these sessions in partnership with the Goldfields Library Corporation. Tonight's topic is speaking truth to power. It's a really far-reaching topic that we could take in a lot of different directions. Whistleblowers who have the courage to speak up against powerful organisations, people who speak out against sexual harassment, investigative journalism, civil society movements, they're all examples of people speaking truth to power. Tonight, we're largely going to focus on Australia's protections of human rights and what we can do to uphold those. Australia was one of the architects of international human rights agreements following World War II. However, we've regressed a long way since then, and human rights protections under Australian law are really out of step with comparable legal systems in other democratic countries. There are many complex reasons that contribute to Australia's failure to uphold human rights, and I'm sure that these will be explored by our panel tonight. How we protect human rights affects the way that we function as a democracy and our health of the community and the health of our community, and that's why we wanted to explore it through Talking Justice. Due to human rights protections in Australia being inadequate, it means that civil society, the media and independent commissions have a really important role to promote and uphold human rights. We're really fortunate today to have three incredible guest speakers from across these sectors who I'll introduce in a moment. What we're really hoping from tonight is that it will stimulate those of you who are here to learn a little bit more and to join us in speaking up to protect our democratic rights and freedoms. There is power in numbers. So our first speaker tonight and keynote speaker is Professor Gillian Triggs. Gillian served as President of the Australian Human Rights Commission from 2012 to 2017. She's held many significant academic positions, including Director of the British Institute for International and Comparative Law and Dean of Law at the University of Sydney. She is currently a Vice-Chancellor's Fellow at the University of Melbourne and Chair of Justice Connect, who are an organisation based in Melbourne and Sydney, and they just do some incredible work. As President of the Human Rights Commission, Gillian advocated for the disempowered, disenfranchised and the marginalised. And for those of you who followed Gillian's time at the Commission and saw the media coverage at the time, you will know that she withstood relentless political pressure and media scrutiny as she defended the defenceless for 5 tumultuous years. Please join me in giving a big warm welcome to Gillian.
Well, good evening, everyone, and thank you for that lovely warm welcome. I'm really honoured to be part of this event tonight and absolutely delighted to see so many of you here and interested in this topic of talking justice. My husband and I had a beautiful drive up here this evening to this lovely, beautiful historical town where we haven't quite got over the fact that we're staying at the Shamrock Hotel. And the hotel room you need to hike across to get from one end to the other. It's absolutely enormous, truly beautiful, and a lovely reminder of Australian rural and provincial history. So thank you very much for a very warm welcome. And can I also acknowledge the traditional owners of the land and respect their elders, particularly if there are any here this evening. But I also wanted in particular to acknowledge the generosity of the people of Ballarat in relation to the Karen people. I understand there are 1,000 Karen people living in this region, and that you've wrapped around them and made sure that they've settled, their children in schools and their parents working, living well. And I think that that's a really great illustration of just how remarkable the rural communities can be. Particularly, of course, rural Australians for refugees. I know there are some here this evening, so thank you for all the work you do. And I think it really shows Australians and the values that are so important to us. Well, I did want to, of course, speak to the topic of speaking truth to power. It's a wonderful topic. It's a great phrase, but it's a little bit presumptuous because, in a way, why would I have any corner on truth? Why would I know the truth any better than anybody else? But I have written a book called Speaking Up, and it really is about my 5 years as President of the Australian Human Rights Commission. Well, in my former life as a commercial lawyer, an international lawyer, and an academic, I've written some absolutely riveting titles on international law. The Theories of Territorial Sovereignty, The End to the Absolute Immunity of States from Jurisdiction, and Boundary Disputes in Exclusive Economic Zones. Well, not surprisingly, none of you will ever have heard of these or read them. But this is the first time that I've ever written a book where the sentences begin with the personal I. It was a book I wrote in splendid isolation up in the high country up near Mount Buller in Victoria. I left my husband behind and took the dog Oscar, and I had a bottomless glass of gin and tonic very close to hand. But as I wrote the chapters and sent them off to Melbourne University Publishing and that wonderful publisher, Louise Adler, I was getting the responses back from Louise, very respectfully, courteously, to say, well, Gillian, the law stuff is fine, but how did you feel? That's what people want to know. So I did go back to the drawing board and try a rather more personal response to the major human rights issues of my 5 years as President of the Human Rights Commission. And this was quite a new experience for me to write in a more personal way. But I did enjoy it enormously, and I hope that you do too if you get a chance to read the book. The book is very different from anything else that I've done because it's the legal and political challenges in a context in which, in the public eye at least, and certainly in the political eye, I morphed from being a quite conservative international lawyer, a so-called black-letter lawyer, into an allegedly politically biased left-wing radical. But my job as President of the Human Rights Commission was to hold the government and the private sector to account for compliance with the international human rights treaties, which Australia had accepted, signed and ratified from those early days, and many in this audience will know this well, of that remarkable, feisty, brilliant lawyer, Dr. H.V. Evatt, who went to the Dumbarton Oaks outside Washington to negotiate the Charter of the United Nations, which linked, for the first time, the need to respect human rights with world peace. That was the underlying aim of the Charter of the United Nations. He was asked back by Eleanor Roosevelt to help to draft the 1948 Universal Declaration on Human Rights, which passed under his presidency of the General Assembly without a single negative vote. That was a remarkable achievement, and he set the foundation for what became Australia's very strong role as a good international citizen, all the way through the development of the modern treaty law, right up to the creation of the International Criminal Court in The Hague. We have the Refugee Convention, many of you will be familiar with it, the Convention on the Rights of the Child, the International Covenant on Civil and Political Rights, the Race Discrimination Convention, the Sex Discrimination Convention, and many, many, many others. All of them were a statement by Australia that we stand in the international community as committed to fundamental human rights. So they were important years, and that was my job, really, at the Australian Human Rights Commission, to hold the government and the private sector to account for compliance with the major ones of those treaties, particularly the International Covenant on Civil and Political Rights and the Convention on the Rights of the Child. But in doing this, I found myself in a political maelstrom, challenging government policies that are, for the most part, supported not only by the government of the day, of course, but by the opposition as well. And that, I think, poses a threat to a vibrant representative democracy, a very uncomfortable position that was compounded for much of the time, but fortunately no longer, but compounded then by the support for the illegal asylum seeker policies by many in the community. It's very interesting that over these particularly the last 18 months that I've been around the country talking to people, nothing to do with me, of course, but nonetheless, a shift in mood and a shift in a sense of a more humane policy, and I'll come back to that in a little while. But the primary message in my book, and the primary message I have in speaking to this topic about speaking truth to power, is that each of us now, in civil society, in the community, if the legislature and executive government cannot get it right, we have an obligation as citizens to stand up and to speak up for the common law freedoms and human rights that have underpinned our relatively successful multicultural and democratic society. Rights that I believe have gradually been eroded over the last few years. I believe that we've regressed as a good international citizen from those heady days of Doc Evatt all the way through to the 90s. We are now regularly criticised by the United Nations Human Rights Council, just a couple of weeks ago, yet again, for our asylum seeker policies, and in particular for offshore processing. But also, of course, we're criticised by our closest allies, also for the world's highest rates of incarceration of our Indigenous peoples and for rising domestic violence and homelessness. Well, of particular concern to me personally, I'd have to say, is the extent to which women in the public arena are the subject of personal abuse by governments and by segments of the media. Whenever I speak about this issue, I have fresh and disturbing examples to talk about. A month ago, it was the CEO of the ABC, Michelle Guthrie. And a couple of weeks ago, it was Alan Jones bullying Louise Heron, the CEO of the Opera House. Well, I, of course, have had my own day, notoriously, in Senate estimates and other media contexts, criticising the role that I played and hope to play fairly and objectively in the Human Rights Commission. But I do have now 41 cartoons of me that I will take great pleasure in describing to my grandchildren when they're old enough to understand what the devil was going on. The most recent was, in fact, a couple of weeks, so the Murdoch press hasn't given up on me. But I have some wonderful cartoons. One of me I've been shot by the Attorney General, and I'm a trophy on the wall, and he's sitting there at his desk in Canberra with his feet on the desk holding the rifle, but he has in fact also shot himself in the foot. There's another one of me with the entire gang at the Australian Human Rights Commission as a bikie gang riding the bikes with tats up our arms, and we were there trying. Of course, you don't always protect people you necessarily find particularly pleasant, but in this case we were defending bikie gangs in Queensland who were subject to an additional 25 mandatory sentence years in jail if they were associated with a vicious, lawless motorcycle gang under the Queensland legislation. So that was a lot of fun with my colleagues, but also a cartoon that was my absolute favourite. It was the James Bond cartoon. And it's me, and in all good James Bond movies, at some stage the hero, or in my case the heroine, is dangling from a hook above a shark-infested pool, and in the pool is floating a submarine, which is Mr. Abbott, and sitting on the submarine is the Attorney General in a smoking jacket, stroking a cat. Well, I'm dangling by the hook, but I'm clearly going to escape up a rope ladder to a helicopter waiting above. And the running line underneath the cartoon was Triggs, Gillian Triggs. I really like that one. So there were some fun moments, it has to be said, and a huge privilege to work with my colleagues at the Human Rights Commission, and indeed colleagues from the community legal services all over Australia. Really supported us, along with the Knitting Nanas, the Older Women's Network, and of course Rural Australians for Refugees, and all the many asylum seeker alliances. So it's been an extraordinary time, and I did try to write about it in the book with a chapter really on some of the things that particularly concern me. One being the regressive position of women in Australia. It is really shocking for my generation, educated at the University of Melbourne, down the road, in the 60s. The opportunity, the optimism for women at that time was quite extraordinary. We rode the crest of a wave, imagining that questions of discrimination in employment would be well and truly gone by the turn of the century. But here we are, in the second decade of the 20th century, in a sadly regressive position. We've not achieved anything like as much as in those heady days of the 60s we thought we were going to. We were a bit pretentious. We read Simone de Beauvoir's The Second Sex. We talked about philosophers, Kierkegaard. We, at least metaphorically, burned our bras. We walked behind Jim Cairns in the Vietnam moratorium marches. We had a great time. We had absolutely no idea what we were talking about, but we got in there. We were very politically active, and I think in a way my generation has maintained some of that spirit. But it is shocking now to look at the figures of the World Economic Forum's Gender Index, to observe two facts, one of them very positive, and you won't be surprised by it. Australian women, young girls, are the best educated, number one in the world for educational attainment. But we have slipped on the general assessment of political and economic empowerment of women in Australia from 15th 8 years ago to 46th 2 years ago. And there are extraordinary statistics that I find quite amazing. The fastest growing group of homeless in Australia are women over 55. And that brings tears to my eyes even to think about it, that these are women who've often had children, took a lot of time off to raise their families, or with caring responsibilities for older parents, who missed out on superannuation. On average, women retire on 46% of the superannuation that men do. They've had flexible jobs, casual, unstable work, and too many of them have been forced into levels of homelessness. It's a taboo subject. They stay a few weeks with a son or a cousin or an aunt or one of the other children, but too many of them end up in cars or sofa surfing, ignominiously poor. We have high levels of domestic violence in the community, and one of the highest in the world. I used to be very cautious about saying 1 woman a week is killed by her partner or former partner. The last few weeks have pushed that statistic up to more than 1 woman a week. It is simply shocking, and it's something we need to be dealing with. We have extraordinary lack of job security and casualisation, but we also, at a more general level, have matters that are of particular concern to me, which is the denigration of democratic institutions, including the Administrative Appeals Tribunal, our courts, statutory bodies, the Australian Human Rights Commission, but of course the ABC itself. We have a failure to recognise Indigenous Australians. We have the Northern Territory intervention in which the Racial Discrimination Act was suspended, and we have reports on the Dondale Detention Centre, which led, including reports from the Australian Human Rights Commission, along 2 years later with reports on the Four Corners program that showed the CCTV footage and the picture of that young man, a young Indigenous man, in steel restraint and a spit hood. And it makes the point for me that while we can, at the Human Rights Commission and many others around the country, conducting serious factually based research to inform policy backed by law, particularly international human rights law, but the common law principles, no man may be detained arbitrarily without charge or trial, And yet those reports sink like a stone in Parliament. And indeed, as is notoriously known, the head of the Legal and Constitutional Joint Parliamentary Committee refused to read the report on the forgotten children. But the extraordinary fact is that that very same problem at Dondale, the use of the steel restraints, was exposed in those iconic photographs and CCTV footage on the Four Corners programme. And the following day, the Prime Minister rings to say, should we have a Royal Commission? I'm sure he consulted many other people than me, but there we are, within a very short space of time. For my generation, the iconic picture was of the young girl running down the streets in Hanoi, escaping napalm burns. For others, it might be the crumpled body of Hélène on the Turkish beach. Well, there's that issue. There's also religious freedom and marriage equality that I'm sure Hugh de Kretser will say a little bit more about, but an extraordinary debate in which attempts were made to suggest that religious freedom is not protected properly in Australia, but also the freedom of speech issue and Section 18C, the very difficult question of whether or not that provision should be amended, and the extraordinary response from Multicultural Australia to ask the Australian Human Rights Commission to stand by Section 18C, a very simple provision. No one may offend, insult, humiliate and intimidate somebody in the public arena because of their race. That is where Australia, more than 20 years ago, under Michael Lavarche, the Queensland Attorney General, drew the line on limits to freedom of speech. The language may not be perfect. It could be all laws can be amended and improved. But the difficulty was that this was so highly politicised that sensible discussion could not really resolve the question. But then we have the problem, of course, of asylum seekers and refugees that really did drive much of my time at the Australian Human Rights Commission. What I attempt to do in the book is to dispel so many of the myths, and the myths is a nice word. Much of it was lies about the law and about the need to detain refugees and asylum seekers. I'm still shocked by the willingness of people to accept the false binary that you need to detain children and their families on Nauru in order to stop the boats and save the drownings at sea. But it was brilliant communication by Mr. Abbott and by many, many others, including the former Prime Minister just last week on the Q&A programme. There is no evidence whatever to indicate that you need to detain children for 5.5 years on Nauru in order to stop the boats or to stop drowning at sea. The boats are being stopped because of an armada at about $1 billion a year of Coast Guard shipping with collaboration with Indonesia, in some cases Sri Lanka and Malaysia, to turn boats around. That and other measures have broken the people smugglers' business model and has effectively created a cordon sanitaire around the north and northwestern parts of Australia. It's a policy, of course, that most Australians support in the sense that we must defend our borders. It's entirely appropriate that we do, and it's entirely appropriate to defend national security. But in my view, we do not do so at the cost of the lives of those 600 or so men that are still on Manus Island, the hundreds that still remain on Nauru, and about 1,300 that remain in detention in Australian detention centres. The condition of these people... But in a way, what I'm saying is well known to you, and in a way, not only is history, but it remains the position today. But what I find particularly distressing was the statement by our new Prime Minister, Scott Morrison, that all the children will be brought back to Australia by Christmas. A statement made during the Wentworth by-election. Now, when a journalist, in fact, rang me to ask for my comment on that, I perhaps unwisely and cynically said, Scott Morrison made that promise when I was President of the Human Rights Commission and he was the Minister for Immigration some 2 or 3 years ago. It didn't happen. I'm not that sure this is going to be true this time around. And then I thought, no, that's a bit harsh. In the context of the Wentworth by-election, this is a commitment. Those children will be off the island by Christmas. Well, I don't know whether you saw the news today, but apparently Mr. Morrison is now saying that he never made any promise that the children will be back and brought back from Nauru, and that those children that have reached Australia for medical treatment are now being returned to Nauru once they've received that treatment. Now, I'm a bit of a Pollyanna. I'm always optimistic, but I must say I'm deeply, deeply shocked by that news, if true today, that there is a cynical determination that the New Zealand offer, if it's still on the table, it will not be accepted. Now, I want very briefly to say, how has it come to this? How can I run through all of those issues that are a matter of concern to human rights lawyers and to the Australian community? How did it happen? Well, one extraordinary truth is that Australia is the only democracy in the world that does not have a Charter of Rights. Now, I'm not talking about a constitutionally entrenched Charter of Rights, but I think it is time we looked at a legislated charter to provide us with a benchmark which would give the courts the power to ensure that we meet fundamental principles of common law and international human rights law that we've signed up to, as I've said. Not only is that an extraordinary fact, but also our Constitution is one that doesn't really deal with fundamental freedoms, with some exceptions. We have a right to judicial review. We have a right to religious freedom in our Constitution. We have a doctrine of separation of powers. But the kinds of rights that most Australians would think would be in our Constitution, the right to freedom of speech, freedom of association, privacy, the right not to be detained arbitrarily without charge or trial, as old as the Magna Carta, these provisions are not in the Constitution. What I'd like to... the other point also is not only do we not have a charter, and the Constitution is essentially a federal state body, but but the treaties that I've mentioned to you that emerged from those years of the 40s and 50s have, for the most part, never been implemented into Australian domestic law. There are two exceptions, the Racial Discrimination Act and the Sex Discrimination Act. And in fact, I might mention very briefly that one of my colleagues at the Australian Human Rights Commission was the rather marvellous Susan Ryan. And you might recall that she was the first woman ever to be appointed to a Labor cabinet. And when things were a bit grim at the Human Rights Commission, she said, "Gillian, go back and have a look at the press cuttings of 1984 when, as Minister for Education in the Hawke government, I introduced the Sex Discrimination Act." And I did. And she was subject to the most extraordinary vilification simply for wanting to give the Convention on the Elimination of Discrimination Against Women a legislative base in Australian law. But most of the other treaties, the International Covenant on Civil and Political Rights, the Convention on the Rights of the Child, the Refugee Convention, economic and social rights, and so on, have not been implemented as part of Australian domestic law. And that means that our courts have a great deal of difficulty in overcoming the legislative provisions passed by Parliament under the principle of parliamentary sovereignty. Now, I will finish, because we want to get on to the other speakers and also to get as much public discussion as we can. But I thought I'd finish on a more positive note. And that is to draw attention to the fact that sometimes we can get it right. And there was a decision by a single judge of the Federal Court just a few months ago, and it concerned one of the many, many cases of children on Nauru with profound medical illness, frequently attempting suicide and meaning it, great cries of distress, and increasing now numbers of children who are not eating properly and are now on a special watch to make sure that they are eating some fluids and staying alive. Many of these children have been the subject of requests by the senior medical officers to the Super Ministry of Home Affairs to bring them back to Australia for medical attention. There are many cases, but one in particular was taken up by these wonderful pro bono litigation lawyers who give their time to these cases, and government officials fight hard against them. But this particular matter was brought before the Federal Court, asking the Federal Court to require Mr. Dutton to allow that child, a little 9-10-year-old boy, to come to Australia for medical treatment because he was so sick that there was even doubt that he would survive. Mr. Dutton had refused over 9 months, and his senior officials had refused over 9 months to allow that child to come back into Australia for medical care. But this Federal Court judge didn't talk about any of the things that matter so much to me. He didn't look at the Convention on the Rights of the Child or go into some statutory analysis of the Migration Act. What he did was to look at the classical Australian common law, developed over millennia. And he said there is a very simple principle of law, and that is that Australia owes a duty of care to these children. They've come within our jurisdiction. They've sought our protection. Most are found to be refugees on Nauru. We owe them a duty of care. We owe this child a duty of care. And he ordered Mr. Dutton and his department to allow that child and his mother to come to Australia for medical attention. But then he did something that I've never seen a judge do before. He checked the flight schedule. And he said, there is a plane tomorrow morning, and I expect to see that child and his mother on that plane. End of judgment. I believe that Mr. Dutton did as he was instructed by the court. So I haven't given up on the law, and I haven't given up on Australians returning to those values that were so important from the 40s up until the 90s. I believe that Australians now are saying, whatever your views, politically or about the need to protect border security or to stop boats arriving with asylum seekers without visas, whatever your views on those subjects, we now have surveys that suggest that about 80% of Australians say that is enough. 5.5 years on Nauru is enough, whatever your views. It is now time to address this problem, whether we do it through the New Zealand offer, but that won't mop up all of them by any means. We need now to face the fact that this is our responsibility, our duty of care, and we now need to respond to those issues. So I have landed, after all of these years, on a very, very clear view that we now need to go back to the idea of a Charter of Rights to provide the courts with more tools to be able to challenge egregious breaches of international human rights law by Parliament and by the expansion of executive powers. So thank you all very much, and I look forward to the other speakers. Thank you. Thank you. Thank you.
Thank you very much. And I've got to tell you, it's not very easy giving you a 2-minute wind-up because I could have sat and listened for much longer. So I did that under instruction as well from Gillian. So thank you very much. It was interesting reading through your book. I could have taken many quotes from that, but there was one that really stuck with me. And I think on a personal level, it stuck with me when I think about different situations that I've been in, but also watching you speak out for many years. And it was, all that I can advise is get the facts and the law right, act with integrity, and focus on what you know to be true, then never stand down. And I thought that that was an excellent quote. Thank you. Next, I have the pleasure of welcoming Hugh de Kretser. Hugh is the Executive Director of the Human Rights Law Centre. Hugh did tell me to gloss over and go quickly through his bio, but I'm not going to, because I think that there's some really substantial things in here that need mentioning. So Hugh, you might have to squirm a little bit there. So Hugh started his legal career at the firm of Mallisons, and then began working to protect and promote human rights as the manager of Brimbank Melton Community Legal Centre, and then the executive officer of the Victorian Federation of Community Legal Centres. Hugh currently serves as a director of the Victorian Sentencing Advisory Council and a member of the advisory board of the University of Melbourne Law School. He's previously served as a commissioner of the Victorian Law Reform Commission, a board member of NACLAC, which is the National Association of Community Legal Centres, and a governance committee member for No More, which, for those of you who don't know, is a national service that provided legal help for people navigating the Royal Commission into institutional responses to child sex abuse. I'd like to welcome you. Thank you.
Thanks so much, Hayley, and thanks to everyone for coming. I wanted to also acknowledge that we're meeting on Dja Dja Wurrung country, and to acknowledge, as Hayley said, the absolute importance of the issues we're talking about to the rights of Aboriginal and Torres Strait Islander people. It's really fantastic to be able to accept an invitation from Loddon Campaspe Community Legal Centre. As Hayley said, my career has been a lot to do with community legal centres. I worked around the country looking at different community legal centres, and you're very lucky here in Bendigo to have absolutely one of the best community legal centres in the country. It's good Hayley walked in just as I said that as well. It is, of course, 1 year today since the vote, the plebiscite announcement or the survey announcement was revealed. It was an unnecessary and very divisive survey, but I want to really remark on that and thank everyone who voted for equality and for dignity for LGBTI Australians. It was really an amazing day. And finally, I just wanted to acknowledge Gillian Triggs. Gillian lectured me in law, international law, a very long time ago, and I was at the Human Rights Law Centre when Gillian was president of the Human Rights Commission. So I saw very closely the attacks, the awful attacks on her, and the resilience and the strength and the leadership she showed to speak up and stand up for human rights in the country, and we're all very grateful for what you did. For me, speaking truth to power is about having the courage to speak the truth, even if those in authority will be hostile to what you say, and even if they will engage in reprisals against you. And there's many historical examples of people who have spoken truth to power at great personal cost to themselves. But I want to focus on contemporary Australia to highlight a corrosive trend that's affecting our democracy and how it impacts on those like Gillian who speak truth to power. A few years back at the Human Rights Law Centre, we embarked on a project which we called modestly our Safeguarding Democracy project. This was a project that was premised on the fact that our democracy doesn't start and end on election day. Rather, the health of our democracy relies on some very important foundations, like the ability of civil society, of NGOs, charities, community groups to speak up about the work that they do. It relies on our press freedom. It relies on our rights to gather together and speak out and protest about the issues that we care about as communities. It relies on the rule of law, and it relies on the role of the courts and other institutions like the Human Rights Commission to hold government accountable. And when we looked at these issues and when we talked to colleagues across civil society, we really saw an unmistakable trend of governments, both at the federal and state level, of undermining these vital foundations. I'll speak a bit more on NGO advocacy because I know Misha is going to talk about the media. When you look at the NGO sector, it's absolutely vital to the health of our democracy. The charities and community groups are freely able to speak up about the work we do, whether that's running a community legal centre, running a family violence service, running a homelessness service, or defending the environment. Yet we've seen governments at state and territory level using a range of different levers to make it hard for NGOs to speak up about their work, and governments intimidating NGOs when they do speak up in a way that is uncomfortable for government or where it criticises government. The Abbott government in particular in 2013 and 2014 engaged in a range of targeted funding cuts against organisations that spoke up, and this was particularly in the refugee sector, in the environment sector, but also for peak bodies in the Indigenous sector, homelessness, disability and the like. At the same time, it changed funding agreements to stop the funding of advocacy and to remove clauses that had explicitly said you are able to advocate. And this sent a message from government in a climate where organisations were having their funding cut and were worried about their sustainability and their staff. It sent a message that we don't value advocacy, and if you do advocate in a way that makes us uncomfortable, then your organisation is threatened. The Newman government in Queensland went further, and it had explicit gag clauses in funding agreements with community organisations that said, where an organisation receives half or more of its funding from the Queensland government, it must not advocate for state or federal legislative change. So even if you're a family violence organisation seeing the court system not work properly, seeing the legal system not work properly, you must not speak up about what you see. You weren't even allowed to include a link on your website to other organisations that might advocate for policy change. These aren't the actions of a government that's confident in its own policies or comfortable with a robust debate informed by a diversity of voices and perspectives, and that's exactly what charities like Loddon Campaspe Community Legal Centre, like other charities, bring to bear on public debates about laws and policies, the perspectives of the people that we work with. Even when organisations weren't funded by government, the federal government was looking to use levers to put pressure on them. We have charitable tax status, we rely on donations, people get a tax deduction for donations made to us, many environmental organisations in the same category. The government was attempting to say that if you advocate as an environmental organisation, your deductible gift recipient status, your charity tax status was threatened, and they said you should be planting trees essentially, not advocating to stop the pollution going into the river in the first place, which, as we know, is a far more effective way of protecting the environment. More recently, we've seen the appointment of a new commissioner of the charities regulator who has made statements which are very hostile to charity advocacy, and we've seen these so-called foreign influence laws proposed in the federal parliament, and we have spent a year of absolute hard slog trying to get these laws fixed. I'm pleased to say that the version that is going through the Senate today is a far cry from the version that was introduced last December into the parliament, but that was a very deliberate attempt to stifle advocacy, to stifle criticism by charities, by community groups that made life uncomfortable for government. The cumulative impact of all these changes and the funding cuts on our sector has been profound. We did a survey with Pro Bono Australia and Melbourne University of the non-for-profit sector that showed 92% of respondents agreed that economic power and strong vested interests are the main drivers of government policy. 69% agreed that dissenting organisations risk having their funding cut. 53% agreed that NGOs are pressured to amend public statements in line with government policy. And it's why it's so critical for organisations like ours that speak up in ways and litigate and sue the government that we get independent funding, because that is a guarantee of our independence, and the government can't cut our funding. But like I said, there are different ways, different levers governments use to try and pressure NGOs to suppress their criticism of government, particularly in the environment sector. Just on press freedom, we've seen a real intensification of secrecy. We've seen the border force laws, ASIO laws, special intelligence operation laws that threaten journalists and others that talk about these operations with 5 or 10 years jail. We've seen the introduction of metadata laws that allow the government to expose confidential sources of stories that might embarrass government, and we've seen those laws used against journalists and their sources who've exposed stories around the treatment of asylum seekers and the way that boat turnbacks have infringed international law and boundaries. And we've seen the awful prosecution of witness Kay and Bernard Collaery for their role in exposing the illegal bugging of the East Timorese Cabinet Office at a time, by the Australian Spy Agency, at a time when Australia was negotiating oil and gas revenue with East Timor. And so to thank them for their role in exposing that kind of misconduct, we've seen them now prosecuted with a risk of up to 2 years jail if that prosecution succeeds. I'll wrap up. And attacks on protest rights, attacks on institutions like the Commission, attacks on the rule of law. Maybe just to finalise, for me, speaking truth to power isn't necessarily about exposing the truth to government and those in power. Really, they know the truth. I saw Noam Chomsky said power knows the truth already and is busy concealing it. For me, speaking truth to power is about exposing the truth to the public. Because when you look at issues like the treatment of refugees and people seeking asylum, the government is doing that in ways which are deliberately secretive, which are deliberately locking people up on offshore islands far away from the rule of law, far away from journalists, far away from human rights advocates. And the change that Gillian's remarked on has been the result of years and years of hard work by many individuals and many organisations to break open cracks in that regime, to show people the human faces of the people who are subject to this regime, the men on Manus, the kids and their families on Nauru, the babies who were born in Australian hospitals, whose faces we put on the papers and in the media when they were at risk of being sent back to Nauru. So for me, it is the power of those voices, those faces and those stories which are so absolutely critical to standing up for human rights. And thanks to Loddon Campaspe and Arc Justice for putting on this show tonight, for putting on this talk tonight, because it really provides an opportunity for all of us to stand together and resist these attempts to prevent the Australian public from hearing about these kinds of issues. Thank you.
It's interesting, as I was listening to Hugh speak just then, about the way in which community organisations are restricted from speaking out. I was on Twitter on the weekend and I started crafting a message that was critical, like very fairly so, of some human rights treatments of the government. And then this little cog starts going through thinking, hey, which funding do we get from there? And what percent is that? What impact is that going to... And all these cogs start going through. But we're a human rights organisation and we're fighting for social justice, and the fact that I have to think through those cogs is, it just demonstrates how vital it is that we've got organisations such as the Human Rights Law Centre who have that independence and can speak out and highlight some of those issues. So I recommend, I'm sure many of you are very familiar with the work of the Human Rights Law Centre. If not, check it out. Thank you, Hugh. Great. So I'm very pleased that our last speaker tonight could join us, as I believe the media plays a pivotal role in the protection of our rights via influencing public opinion and also holding governments to account. Misha Ketchell is the editor of The Conversation. He has been a journalist for more than 20 years, and in previous roles he was founding editor of The Big Issue Australia and editor of Crikey, The Reader and The Melbourne Weekly. He worked for The Age as a reporter and feature writer and spent several years at the ABC, where he was a TV producer of Media Watch and the 7:30 Report and an editor on The Drum. So an extensive media history, and I really look forward to hearing from Misha tonight.
Thank you so much, Hayley. I'd also like to start by acknowledging the traditional owners of the land on which we meet and pay my respect to their elders past, present and emerging. We've really started off so far tonight by talking about areas in which we see failures and problems and threats really to our democracy and our democratic systems. And unfortunately, I'm going to continue that trend. What I really want to talk about is media failure and the role of media failure in the problems we've been talking about so far tonight. And I'm going to go back really to my time when I was at Media Watch, when I was working and spending a lot of time talking on the phone to people who had been basically attacked or maligned very frequently by the Murdoch press, and in particular by the Australian newspaper. A very well-known and highly regarded Australian academic, Robert Mann, actually wrote a quarterly essay about the Australian newspaper and its modus operandi and the way in which it works to influence public debate. And I've just picked out before I came a few quotes from this, because this was something I saw very much firsthand, and also I saw very much in the treatment of Professor Triggs during her time leading the Human Rights Commission. Robert Mann says, "The Australian is ruthless in pressuring those who oppose its worldviews. It's a remorseless campaigning newspaper. It sets out to destroy people. It never forgave Simon Overland, he's the former Victorian Chief Police Commissioner, for having the temerity to complain about their coverage of a terror raid. I've seen in my time the Australian newspaper go after Gillian Triggs, Simon Overland, an academic called Julie Passetti, an academic called Larissa Barrett, an academic called Margaret Simons, Monica Attard, who was my colleague on Media Watch. That's just to name a few. And when I say go after, what I mean is that newspaper, which decides it will have a perfectly reasonable and legitimate ideological difference with a view that somebody is putting forward, will run story after story after story after story to destroy that person's reputation until they leave public life. That's what they do. And it's very, very hard to really grasp the extent to which that has a chilling effect on public debate and public discourse in this country. The Australian's actually a relatively small newspaper. It has a circulation, I think at the time of Robert Mann's essay, it was around about 100,000. Now I think it's in the 60s or 70s. It's only a relatively small audience nationally, but it's hugely influential because it's read by everybody in Parliament House, and it's taken very, very seriously. And I spoke to lots of people when I was at Media Watch who basically said to me, I'm not going to engage in public debate anymore. I don't want to participate. It's just too traumatic. It's too risky. It's too frightening. What happens when you have the media failing in that way is that you can't actually have serious evidence-based discussions about matters of public policy. I was really interested to hear Hugh talking about the role of community organisations, NGOs and not-for-profits in lobbying. I was actually at an event in Parliament House last year, I think it was last year or the year before, run by Philanthropy Australia, where they were talking about the fact that that the community sector needed to make sure their voices are heard. And John Daly, who runs the Grattan Institute, said, this place, Parliament House, is teeming with people lobbying for vested interests. But who here is lobbying for the public interest? Unless you've actually got organisations like community organisations or legal aid organisations or groups that are actually in touch with the community and advocating for public interest, you don't have those inputs being reflected in policy decisions, and that's how you get poor policy outcomes. We're now at a stage where, for the past decade, there's been declining trust in democracy, declining trust in politics, declining trust in our political institutions, declining trust in experts and expertise. The whole system effectively is a mess, and we're seeing the media go through a very difficult time financially, which has destroyed the business models of a lot of media organisations, and many of them now see that the only way to prosper is to be increasingly shrill, increasingly aggressive, increasingly intimidatory. So there was a time many years ago when you might have a sober newspaper which would run articles by people who might say, on the one hand this, on the other hand that, but the evidence says this, and you would get like a good primer on a policy question. I think increasingly you're seeing less and less of that in the media. Media is like a theatre of conflict. The reason this happens is because media proprietors know that if you're trying to reach a mass audience, you need to entertain that audience with a certain type of entertaining content. The downside is that we don't get the serious discussion of major public policy issues that we need. And so we have our debates largely uninformed. And in addition to that, we have the problem, which you identified, of governments trying to do things in secrecy. And there's been a massive increase in legislation and government activity which impacts on our right to know. So overall, it's a pretty grim scene. I think it's terrific that there are people like Gillian Triggs and Hugh de Kretser out there who are fighting to raise issues against the tide and who are prepared to weather the personal attacks that they have to weather. And, you know, I think when you have a reputation and you work for a very long period of time, it is frightening and more difficult than you can imagine to be in the middle of that. So I sort of really tip my hat to both of you for the work you do. But I think in any discussion about speaking truth to power, we've got this sort of romantic idea of the media speaking truth to power in a very sort of public interest, public-spirited way. One of the things we need to be aware of is that the reality is often the media is providing what the public is interested in, not what is in the public interest. And unfortunately, the collapsing business models for the media have limited the places and the spaces where you're getting that really good quality public interest journalism. So on your list of problems to be fixed, I think, you know, obviously there's lots to do on the major public policy questions, but also the system itself that enables us to have a sober debate, understand the issues, respectfully disagree, and reach a conclusion is also something we really need to consider very, very thoughtfully. Thank you very much.
So thank you very much, Misha. I'm going to join you all over there. But before I do, there has been one question that has been coming through about media accountability, and particularly around the reporting around African gangs and looking at how the media can be held to account. And it was interesting on Four Corners just a couple of weeks ago, I was reading an article earlier today where the County Court Chief Judge Peter Kidd says that current media reporting gives an inaccurate portrayal of how much crime goes before the courts is actually being committed by people of African and African community, and the public needs to be properly informed. So the question that we have is, what is being done at an industry level, if anything, to ensure that reporting is fair and balanced?
Okay, good question. Well, look, there are a lot of media outlets that are doing a very good job. I read a fantastic piece in The Guardian that was dealing with this issue in January, and was writing about the fact that if you look at different groups of people with African backgrounds and their representation in the crime stats, they are not significantly overrepresented. They are represented slightly higher than people from non-African backgrounds, but also that cohort tends to skew slightly younger, and young people tend to commit more crimes. So overall, the evidence is that there isn't a really strong problem in terms of overrepresentation of African people committing crimes. Interestingly, this story is as old as the hills. When I was at Media Watch in 2007, I remember two stories that I worked on, one of which was about a story in the Herald Sun saying that African immigrants were committing crimes, and we did the same analysis and said basically they're not overrepresented in the stats. But that was a straight beat up, which I presume was designed to sell newspapers. The second story I did was, there was this story that ran about some African youths, or youths who appeared to be of African background, who went into a bottle shop, and so there was a bit of a sort of brawl, and some alcohol was stolen. And that story ran on the Channel 7, Channel 9 and Channel 10 news, and it led all of them, and the story was African gangs, running amok. And we actually did an analysis of all those stories. We went and spoke to the person in the bottle shop, we got the footage, and it turned out not one person of African background had actually committed any crimes once you analysed the footage itself. It was other people from non-African backgrounds who were involved in that scene, but it was presented a certain way. Why does this happen? Well, I think, to be honest, it's a cynical media that sees that there is a ratings benefit in playing into that fear and prejudice, that worry, that anxiety around people from different ethnic backgrounds. And unfortunately, they're often in lockstep with our political leaders on this. I wrote an article for the Sydney Morning Herald and The Age earlier this year about this, because when Peter Dutton said that people were afraid to go out to dinner, I thought, finally it's happened, because I was in Parliament House maybe 18 months before that, having a conversation with a very senior minister in the Turnbull government, who was saying, I'm very concerned about these African gangs. This is an issue that I think will be an issue in Victoria. It'll be an issue in the Victorian election. And I don't remember the precise words he used, so I haven't named this minister. But effectively what I took away from it was he was saying to me, we will use this issue to try to help Matthew Guy get elected on a law and order platform in Victoria. And I thought, okay, that's interesting. I wonder when that will happen. And then suddenly in January, I've got Dutton saying people are afraid to go out to dinner. So I think there's a cynicism and a failure on both sides on this issue. I would say it's important to understand that there are genuine issues. There are some people that do commit crime, and there are genuine fears out there. I don't think that, and I think that the Victoria Police were very careful about their use of language to say African youths are not being overrepresented, but we are working with communities and we are working on crime issues. But again, this is a classic example of where you've got something where you've got people who are actually in positions of power in the police trying to do the right thing to serve the community well, and you've got all these other vested interests that can gain by turning it into a conflict that actually doesn't serve the public interest at all, actually just increases division, but they get something out of it.
Brad? No?
Well, I'd just like to add you did take that quote from what I was saying. I think that it's critical, and Hugh's made the point. It's very often about getting the facts and the truth in front of the public, because our politicians know the truth very well. For them, it's simply to be manipulated. But the great challenge in this post-truth world we're in is how to break through the manipulation and the false news. I think you'll all remember the statement after Mr. Trump. We can't talk about this subject without mentioning Mr. Trump at least once. But Mr. Trump said after he had his inauguration, more people came to my inauguration as president than ever in the history of the United States or the universe or the Milky Way or whenever. There had never been as many people there. This was objectively false. And it was clear, and it could be demonstrated that it was false. And Kerry-Ann Conway purported to justify this with the world's media. And she said when that statement was made, she said, they were simply presenting an alternative fact. Now, there's no such thing as an alternative fact. There might be other facts which would moderate your view, but there's no such thing as an alternative fact. And I simply raise that. It's a sort of Humpty Dumpty, words mean what I want them to mean kind of thinking. But the point about identifying this phenomenon of post-truth or fake news or alternative facts is that it actually matters. People really, although we have more access to information today than we've ever had in the history of mankind, we've actually split off into our halls of mirrors and to our social media, and we're not reading the newspapers. Mercifully, we're not reading the Australian, but nonetheless, we're not reading newspapers generally, and it means that what we're doing is getting our news from those sources that actually reflect back our own views, and that's made it paradoxically more difficult today to get the fact out and the truth out, as you said, than ever before. And that is the challenge, except that I believe that if you keep reiterating the facts and supporting it with the evidence, ultimately that will cut through. But it's a very tough environment, and the environment of trying to talk about marriage equality and equality before the law was a very tough fight, and it is over so many issues.
And I also know that you commented, I've seen, maybe it was in your book or somewhere else, but once misinformation has lodged in somebody's brain or in the community, it's very hard to dislodge that.
That's right.
We've got quite a lot of questions coming in here in regards to a Bill of Rights or a Charter of Rights. I might throw this one over to Hugh, as I know that this is something that you speak about regularly.
Yep.
And I guess just one specific one that's come in is from Christine Cummins from Rural Australians for Refugees, saying, I spent 5 years as a torture and trauma counsellor on Christmas Island, and I saw firsthand why we need a Bill of Rights. How can we make this happen?
Yep. So thanks, Christine, for the question. Just on the so-called African gangs crisis, we have to listen to the voices of the African community on that and understand how damaging and counterproductive that media coverage and those political attacks are. Yes, there is a problem. There's absolutely a problem with overrepresentation in particular crimes, and we need to deal with that. The way to deal with that is not by stigmatising that community. The way to deal with it is by supporting that community to address that particular problem and holding that in perspective. What we see is that fear being self-perpetuating, if you like. So the politicians telling people that they should be scared, the media reporting out of proportion to the actual statistics or the real threat to people, and then people becoming scared. and then that perpetuating an environment where you have harsher sentences, more police, and you take money away from the things that actually work to build stronger, healthier communities. And so you have this ever-perpetuating cycle which actually damages community harmony, community safety, all of the things that we care about. On a Charter of Rights, we have just launched a campaign for a Charter of Rights in Australia. I agree with Gillian about everything she said about the need for a Charter of Rights. For me, it's about a tool that transfers power from government to people. So it is, yes, we have an independent judiciary, and we should be proud of the fact that our court system is fair and impartial. There are many problems with access to justice in this country that need to be fixed, but the court system is a very important balance against government overreach. And what we are seeing is that, particularly for vulnerable minorities, where government can distort public opinion against that their human rights are at risk. And all those foundational values, the lessons that we learned through bitter horror and tragedy from World War II about these fundamental values that we all agree that no government should cross over, they are not properly respected and upheld in Australian law. And the Australian Parliament has proved ineffective as a mechanism to guard against the human rights of people across the community. And so we stand in absolute opposition to all of the Western democracies that have a Bill of Rights or a Charter of Rights or a Human Rights Act, however you want to call it. And so this campaign that we've launched, charterofrights.org.au, you can sign up to a petition. We think there is a good opportunity in the next 3 years or so to get this up and running, but we need people to show their support for that, and so we encourage you to go to that website. And we are certainly working in coalition with a range of organisations and community groups across the country to try and generate momentum for this and show that a Charter of Rights will actually help to protect all of the values that we care as a community about, like fairness, equality, dignity, respect, and upholding our common humanity.
I'll just add one point, though, and perhaps ask you about it. Queensland has just introduced a charter of rights, which I've read, and is really quite an exciting document, including protection of the cultural rights of Indigenous Australians. Yep. Do you think that might be a sort of tipping point to bring more Australians behind the idea that we need at least a legislated charter at the federal level?
Yeah, so I think research from people like George Williams has shown that many people in Australia think we have a Charter of Rights, but we don't. Our Constitution was formed as a very minimalistic document, and in fact they didn't want to give rights to people who weren't from Anglo-Celtic origins, so they were worried about giving rights to Aboriginal, Torres Strait Islander people. They were worried about giving rights to non-European migrants, and so they explicitly rejected a Bill of Rights. What we have in Victoria, we have a Charter of Rights. In the ACT, we have a Human Rights Act, and very recently we've got Queensland over the line where they have introduced a Human Rights Bill, which is in the Parliament, and we expect that will go through early next year, and that will be a significant step towards that national momentum that we want for a national Charter of Rights impacting on the federal government and issues like the treatment of refugees, but also things like people with disabilities in the NDIS, Medicare, Social Security, counter-terrorism, federal police, to make sure that government, public servants, public authorities, politicians must think about human rights before they act, and when government crosses the line, people actually have a power to take action in a court to defend their human rights.
But a key element to this whole question, as you suggested, is the lack of information and education in Australia about this legal position. It's a bit tedious to go through it all, but it's a reality that we don't have civics education, and we don't understand the failures of our legal system and why this has happened. And one thing, I think, I've repeated it in the book, but I think the Electoral Commission conducted a survey a few years ago and asked Australians, 3,000 or 4,000 Australians, do we have a constitution? And 48% of people said no. And then when they asked the next question, do we have a Bill of Rights, over 60% of Australians said we do have one. And it reminds me of a news item I saw in the Queensland press a couple of years ago of a man who'd killed his wife, and the police arrived to encircle the cufflinks around his wrists, and he said to the police officer, "I want to take the Fifth Amendment." The reality is that we know more about our legal rights from American television programs than we do from our own education system. And I think one of the things that must underpin any move to a charter at the federal level is a greater willingness in schools to educate about the legal system, to understand what those, even if we put aside everything that I've been talking about in the international area, even if we understood the common law principles, like the duty of care case I mentioned, even that would be a big advance if we understood that better.
Absolutely. I think even just at a very basic level, there isn't an understanding that if there's a common thought that if we've ratified an international agreement, if we've signed up to international treaties, we're protected, but not understanding that if that isn't, in Australian law, there is actually no protections. And very, very basic principles such as that are not understood, and there's so much foundational work to build that knowledge, to have an informed public to be able to have these debates. There's some questions coming in now about offshore processing. And one that's getting quite a bit of votes is saying that given that offshore processing is a bipartisan policy, how can we democratically pressure for change? Are there learnings from other countries that we can use? I'm looking at all three of you. Somebody might want to tackle it.
I can jump in a little bit there. Robert Mann and a group of other academics have written a lot on their view of a potential way forward, which is really to take what Professor Triggs was saying before, which is that the evidence is that the boat turn-backs policy is working sufficiently as a deterrent, so the continued incarceration of people in Manus and Nauru is unnecessary. So the view that's been expressed by those people is that those people could be repatriated to different locations, whether to Australia or New Zealand or whatever else, but need to be urgently removed from Manus and Nauru. You could maintain a boat turn-back policy. You could even maintain some offshore processing as part of that policy, but potentially with a time frame around it, so people aren't left in this situation where they're on Manus and Nauru for 5 years. So that position has been put. Because of the strong bipartisan political support, it's unlikely it's going to be a debate topic before the next federal election. But I guess one of the questions is, if there was a change of government, would we see some movement, or even with a re-elected government, would there be some potential for that? I think that's at the moment the best hope we've got as a political reality sort of situation. I'd be interested in what other people on the panel think, but that's my understanding.
Yeah. Our strategy is we sort of see it as a chair with four legs, this principle of offshore processing, and there's four things upholding that. One is public opinion, two is corporate involvement, three is bipartisan political consensus, and four is the law. And over the past 5-10 years, we've been chipping away at those four things. So we've been stigmatising the corporate involvement because it's been outsourced companies that have been running these detention centres, and so you've seen Salvation Army, G4S, Mansfield, Wilson Security all pull out of that because they say actually that the cost to our business is too high, we're not going to tender for it, and yet we have a so-called family-run company from Queensland called Construct who are profiting substantially now from that, and so we put out a media release today to say to hold them accountable and show their role in this system, which is harming innocent people. On the law, obviously we've been chipping away at the law and breaking little things open. The measures of freedom, the case that was brought in PNG to open the detention centre so people could go out during the day. The same in Nauru. Nauru's obviously an island about the size of Melbourne Airport. It's a tiny place, but that measure of freedom means that people can more easily speak, take photos, send photos, so we can start humanising that, and that's been part of that challenge. It's part of that change over time, where someone like Behrooz Boochani can now speak directly to the Australian people about what's happening on Manus Island. political support, our view is it is not going to change by itself. There's not going to be leadership from Canberra on this. There needs to be change from people in Australia, and that's where, with the Let Them Stay campaign, we saw the first decent shift in public opinion towards a more humane response. Why did that happen? Because working with partners and Get Up and the Church's Refugee Task Force, we're able to show and tell the stories of the babies born in Australian hospitals who are at risk of being sent offshore back to harm on Nauru. And we saw a big shift in public opinion in a short space of 3 weeks. With the current Kids Off Nauru campaign, as Gillian said, you've got now something like 80% support for saying, why are we exposing these kids and their families to harm, and also support for the ludicrous against the absurd position of the Australian government to say it's okay to send people to freedom and safety in the US but not to New Zealand. And so public opinion is changing on that. That public opinion is what will drive political change on this.
Yes, I agree with all of that. These are all strategies to try to shift things, but it's proved to be extremely difficult because of this phenomenon that the policy was introduced by the Labor Party and then adopted and enforced by the coalition. And in the current political environment, I don't think we're going to see any real shift because neither party, most particularly the Labor Party and Mr Shorten, do not want to see this issue as a wedge issue for the next election. In other words, they'll stay as close to the coalition policy as they possibly can until we have an election. If we have a change of government, then I'm optimistic that we will start to see change. The Labor Party has very clearly announced that it would accept the New Zealand offer, which could make a difference, but not a huge difference. But also in their manifesto, they do have a commitment to a more humanitarian approach to the treatment of offshore processing. The question in asking what other international models are there, I mean, Australia is unique in this, in mandatory detention, which is for all intents and purposes indefinite. So there really aren't models that are comparable. I think the better model really is that when an asylum seeker is seeking protection, they be given some sort of status within the community to apply properly in a proper legal system to be refugees. If they're refugees, then they have a right to durable settlement somewhere. And I think that we have to go back to some of those fundamental principles.
There's a question that's come in here from Georgia that is receiving a lot of thumbs up from people. It is saying right now we're sitting here preaching to the choir or people who are on board with these ideas. How do we talk about this with people who don't agree with us? What are the... I guess I'd change that a little bit as well and just say if we were to tackle one or two things, what would they be? You all started there.
Yes, that's right. What
Hugh,
would you change?
yeah.
Well, I've just come from Brisbane where I was speaking to the Australian corporate lawyers, and they were asking me to speak to them about the ethical and moral responsibilities of lawyers. And I put this case of divestment from those companies that are investing in construction and Serco Guards and others on Nauru, for example, but also in Manus Island. And I was interested that a number of people in the audience said, well, if I think it's the Murray Company or Murphy Company in Queensland that's getting on average $39 million a year, $39 million a month.
Is it Construct or?
Yes, that's right. From the Australian government for its work on Nauru, making hundreds of millions of dollars across the year. The argument made by many corporate lawyers was, well, if this is legal in Australia and it's government policy, how could you argue against it? So even amongst sort of educated people grappling with these problems, they're having a lot of, they by no means agree with the position that I'm putting, which is that we need to respect the international standards and respect the common law principles of basic fundamental freedoms. Basically, the right to a fair trial if you're going to be held in executive discretion, administrative detention. So it's extremely difficult, and I do a lot of speaking to faith-based groups, to rural communities, suburban communities, city groups, all over Australia, but far too often I'm doing exactly what's being described, speaking to people who already accept the arguments that I'm putting in one way or another. How do you get to those people who don't agree with you? It's very, very difficult indeed, because they're not going to come out on a cold night in the middle of winter, or even a beautiful night here in
but there does seem to have been a change in attitudes in recent years. There has been some figure that we've seen, like in quite recently. I mean, it does feel like public opinion's turning. What was the figure that there was a poll?
80%
yes.
now are calling for the children to be brought from Nauru.
Yeah. So I think
that's true. There's definitely been a switch, a shift, and I think that's been over the last few months has been very clear to me.
And what's driven that? Where has that come from? What's been the key elements?
I think children is powerful.
Very powerful.
Hard work.
We got that, like the coalition of organisations working on this, Asylum Seeker Resource Centre, World Vision, Get Up, National Justice Project, us, are working closely, hard for years to get these stories out, to get the stories about, tell the stories of it. Like we got a story in the front page Daily Telegraph. So this is not preaching to the converted. If you can get these stories and these photos of the kids themselves into the Daily Telegraph, that is what is going to shift that public opinion and shift politics. And it is bloody hard to do for all the reasons you talked about. But that is what we need to do. We need to break open the secrecy, show the human impact of this, and work really hard to get it before media outlets that actually reach audiences, to reach those persuadable. So there will be a third of people roughly who will support us vigorously, there'll be a third in the middle who will be persuadable either way, and a third who will oppose us regardless of what we say. So it's absolutely critical that we reach those people in the middle and show them what's happening and show them that there's an alternative.
Well, I agree with that, Hugh, but at the same time, that's been true for the last 5 or 6 years. What seems to be making the difference now is, I think, the sheer effluxion of time. If you mention 5.5 years on Nauru, where many of those children were either born there or Brisbane, mothers being allowed to come back to Australia for the birth of their children, I think Australians are... It's effluxion of time, because the stories from the media and from the advocacy groups have been out there for a very, very long time, along with wonderfully positive stories about the refugees settling into the community, the contributions they're making. They've been around for a long time, but I've noticed more recently, when you say to people, these children were born on Nauru, they've been there for 5.5 years, isn't that enough? And I think there's a sense that that is enough. We've got to do something now.
Sorry, just apart from the sentiment bit of that, I think it was in your book, there's sort of a legal principle, isn't there, that governments can't usurp the roles of the courts. So they can detain people if it's justified by statute, and they've got powers to do it. But if that detention becomes punitive... That's right. Where is that at? Is there some sort of case being run on that matter, or is that...
Well, it's an argument that's put in many cases.
Yeah.
But it was an argument that was particularly put, if you'll excuse me mentioning this, is the M68 case.
Yeah.
Perhaps the most notorious of the cases. And if I can very, very briefly explain what happened, this was a woman who'd come into Australian jurisdiction to Christmas Island. She was a Bangladeshi asylum seeker, and she was brought, as the law requires, from Christmas Island to Nauru. She was pregnant, and she was allowed, and there's some humanity in the system, she was allowed to come to Brisbane to have her child. And she then, with her pro bono lawyers, litigation lawyers...
That was us, by the way, so...
Yes.
It was the Human Rights Law Centre working
with
pro bono.
I'm sorry. I'm very sorry. I've forgotten that it was the Human Rights Law Centre. Well, then you should talk to this. But what the point I want to make, and perhaps you could pick up from it, but the point was that she challenged the legislation. And she said, there's nothing in the Migration Act that allows me, or allows the government to return me and my child to Nauru. And the government lawyers looked at this legislation and said, well, as a matter of fact, there isn't anything in the Migration Act that will allow you to be returned. And what the government did, as the case got closer and closer to the High Court of Australia, was to introduce an amendment to repair the defect in the legislation. And this is, if I remember, Section 198 AHA, which most of you would never have heard of. But the question was, did it repair the defect? There were 7 judges on the High Court. 6 of the judges said, yes, it repaired the defect. It was a retrospective provision, and it allows the government to return her and the child to Nauru. But to come to your point, a single judge, Justice Gordon, originally from Victoria, surprising in a way, a tax commercial lawyer, you wouldn't have expected to do this, but she, in a crystal clear judgment, said no. There is in the Constitution a separation of powers, and if you're going to impose a penalty, only the judges can impose that penalty. There is a power of administrative detention, but if it's becoming penal, then only the courts can do it. And she said that the return under this legislation was unconstitutional because it breached that provision. Now, that was a minority view, but it's an argument that has been put, and one that personally I, with respect to her, agree with Justice Gordon, that if the process is one which has become arbitrary and penal, then only the courts can persist in allowing it to continue. If it had been a short-term process, and you're quite right, offshore detention is not in and of itself illegal, but if the process had happened relatively quickly, and the individuals, most of them, 85%, are declared to be found to be refugees, if they then been moved to durable settlement in an appropriate place, then that would have been a reasonably acceptable process. But it's been the effluxion of time without a solution that's turned it from acceptable administrative detention, offshore maybe, into something which is now arbitrary and penal, and in my view, in breach of the doctrine of separation of powers. But it's really your case.
Well, just to finish.
Sorry about that.
That was a good description. But to finish the story, so we knew it was a good argument developed by Ron Merkel, and the government knew it was a good argument, and because we don't have constitutional protection of human rights in Australia, they could wave their magic wand through Parliament and say anything that was illegal is now hereby made legal, and we got one judge in the end. We knew the case was going to be much harder when they did that. We actually went to Labor and said they're going to bring this legislation through. Tony Abbott was on notice for 4 months about it, waited until 2 days before the end of the June parliamentary session, rang up Bill Shorten and said, urgent, loophole in this legislation we need to fix. And Bill Shorten's quote was, it took me 10 seconds to decide whether or not to support this, and he supported the legislation. And then they tried to get access for the Human Rights Commission to Nauru.
That's right.
When they had no political power to do it. And so we went before the court, knew the argument was going to be difficult. We got one judge. The day we launched the Let Them Stay campaign was the day we lost that court case. And that was a campaign about the babies who'd been brought from, and the families who'd been brought from Nauru to give birth for medical treatment here in Australia. Shortly before that campaign was launched, the Immigration Minister said, these families will be transferred back to Nauru within weeks. They are still in Australia. These are kids growing up in playgrounds, in schools, in classrooms, in backyards in Australia, instead of losing their childhoods in the phosphate dust of Nauru. Why has that happened? Because of... Why has that happened? Because of the Australian public, because of the Let Them Stay campaign that showed what was happening to these kids, and the Australian public saying, no, we will not allow that to happen. And several months later, you had Peter Dutton being the minister who was freeing all kids from detention, proudly announcing this on Anzac Day, or just around Anzac Day in the same year. These kids who were being freed from detention were the very same kids he was threatening with sending back to Nauru within weeks. They're still in a very difficult legal position, but that shows the power of the Australian public speaking up and leading, dragging politics with it. And that has been the start of a process of many years. So I agree with you, the effluxion of time is part of it, and people are saying enough is enough. But also there has been a number of different factors that have been bloody hard fought, and it's been defending the gains that we've got and just fighting for those little steps forward that has created this now 80% support to get kids off Nauru.
Absolutely. Just to wrap up, what is one takeaway you would like the audience to take of an action that they can do to create change?
Sign up to the petition for a Charter of Rights at charterofrights.org.au.
Perfect.
Look, I guess my personal view is that the single most pressing issue in Australia today is the people on Madison Road. I don't think there's anything more important than resolving that situation. I mean, we haven't really touched on the reporting of resignation syndrome, this idea of, young people who are effectively giving up. But I think it's just, it's unconscionable. So for me, people's votes, but also their public engagement, their paying attention, their discussion of this matter. Just going back to that question about, preaching to the choir, that's true and it's always a risk, but if you want to raise the profile of any issue, you've got to just basically talk to anyone who will listen to you for as long as you can until you get somewhere. And I think, as she was saying, there's been a huge amount of hard work to get to this point, and there's been some progress made. There's still a huge amount to go. And I'm particularly concerned about what will happen if, the children are repatriated to those people who are still there, who have been there for 5.5 years. So I would say make that your number one issue.
Well, I think my final message really, and the thing that I now feel quite strongly about, is that if Parliament and government cannot protect our fundamental freedoms, ours or those who seek our protection, then I think we've got to bring the power back to citizens and to the people. And I think that means that individually we must accept responsibility for this, and we must speak up. So whether it's in our book group or children's kindergarten clubs or Rural Australians for Refugees being a very good example, but speak up in whatever civic context you have. Get your facts right, it's obviously important, but to speak up and say this is wrong across all of the issues that I was speaking about. But I'd just like now to see much greater community engagement and articulation of these freedoms that have been so important throughout Australia's history.
Wonderful way to wrap up our panellists. Please join me in giving a big thank you. But before we do wrap up, I really need to thank some people who've made tonight happen. A couple of months ago, I put a call out to some local organisations and businesses who've supported Talking Justice in the past, and how quickly they jumped on board to support tonight and to support events into the future was incredible. So a big thank you to the organisations up here: Arnold Dallas McPherson Lawyers, Haven Home Safe, the Stratagem Foundation, Robertson Hyatt Solicitors, Catholic Care Sandhurst, the Reichstein Foundation, and Women's Health Loddon Mallee. We couldn't have done this event without them, so a big thank you. Also, I know I touched on it at the start of the night, but I just want to touch on how happy we are to be partnering with Goldfields Library on this. I think that it's allowing us to reach a different area, a different group of community members, and it's just been fantastic working with you, so thank you very much. Thank you so much, everybody, and I'll hand over to Mark, and farewell from me.
Thanks, Hayley. I won't keep you long. I wanted to start by saying that I lived in Bendigo all my life, and I'm so proud to be here tonight with this engaged audience who is probably just as bloody outraged as I am at some of the things that we've heard tonight. So thank you so much for coming along. It's certainly one of the biggest events we've been involved with. And I want to thank both Melbourne University Publishing and Loddon Campaspe Community Legal Centre for the Talking Justice program. Both been fantastic partners, and the quality of the speakers that we've had tonight is testament to that. As I was sitting there listening to the speakers, I did come up with a solution, and I wanted to ask Professor Triggs whether she would temporarily change her title to Prime Minister Triggs. She's there. Oh, that's good. I thought Hugh could be Minister for Immigration. And why not have Misha as Minister for Communications while we're at it? I do wonder why our our government is so fearful of truth and why they are so fearful of being humane. And speaking truth to power is, I think, Gillian's experience is an example of where power just has no use for the truth, and we see it too often now. And it's really saddening to see what our political parties are doing in terms of just party politics without any regard for us. So I want to thank you all again for coming tonight. Thank you to our partners. Thank you to the speakers. And I'll see you at the library. Thanks.